I was stuck between a rock and a hard place. You want to know what I had to do to get out from under this rock? Come join me on this walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. This was a medical malpractice case. The case had been going on for 2 long years, and now we were approaching a deadline. The deadline was that the court required, and in fact wanted us, to put this case on the trial calendar by a definite date certain. Now, what does that mean? If we put a case on the trial calendar, it means that all discovery is now finished, and we can no longer request or do depositions. It means we can no longer request and obtain medical records. It means we cannot obtain other documents from the defense attorneys in order to go ahead and understand the details of exactly what occurred. Likewise, once we put your case on the trial calendar and tell the court that all discovery is finished, the defense can no longer ask anything of us. They can't ask for additional permission slips, known as authorizations, to get your medical records. They can't ask for any records that we have obtained. They can no longer ask for anything. Why? Because discovery is closed, it's finished, it's cut off. That's what it means to put your case on the trial calendar. So now, how was it that I got myself stuck between a rock and a hard place? Well, I'll tell you how. As this case was progressing, for whatever reason, the defense had not yet produced 2 different doctors whom I had requested be produced. Why? Because I needed their deposition testimony. And in case you're unaware, a deposition is pretrial testimony, and that occurs typically in the defense attorney's office, or alternatively, it occurs on a Zoom video call. The answers that the witness gives me in response to my questions represent sworn testimony and carries the same exact weight as if the witness is testifying in court in front of a judge and in front of a jury. So don't think for a second that giving pretrial deposition testimony is a simple, easy, casual conversation. It's much more than that. So now, in this particular case, I still needed to question these 2 doctors, and the defense had not yet produced them, meaning that there were scheduling conflicts. The defense attorneys were unavailable at the time that the doctor was available. I was unavailable at the time that the other defense attorney was available. There were scheduling issues preventing me from going ahead and questioning these 2 doctors. And now we were approaching the final deadline in which the court required that I go ahead and put this case on the calendar, effectively cutting off the ability for me to obtain these depositions that I definitely needed. So what do? Now I'm stuck between a rock and a hard place. The court says, hey, listen, Mr. Oginski, you have to put your case on the trial calendar. Now you are required to do so by this date. But Judge, wait a second. There's still discovery that's outstanding. We would like you to extend the time that we have in order to put this case on the trial calendar. In this instance, I made that request together with the defense attorneys. I obtained their consent because they recognized likewise that we still had these 2 depositions to do, and because of that, there was still other discovery that needed to be exchanged. So they consented and agreed. So when I contacted the court and submitted a proposed order to push off the deadline to file our note of issue, the court came back to us a few days later and said, no, sorry, counsel, guess what? Your deadline is not being adjourned on consent, meaning we are not going to approve your request to push the filing deadline back. If you want to do that, you have to do it by a formal written motion to the court. Now, in ordinary circumstances, that would be fine. But here's why this was not an ordinary circumstance. It's because I had only 2 days in which to go ahead and file this particular formal written motion. Now, why did I have only 2 days? Because the court said that I had to file this case, put it on the trial calendar by this particular deadline, which was going to take place in 2 days. I would not be permitted to make this formal written request if my deadline had already expired. Then I would be in a terrible position to now ask the court formally to excuse everybody in this case for not completing discovery in a timely fashion. Now, if I make this request before the deadline expires, I am in a better position. But here's the problem. The problem is that even though the court has said, listen, we will entertain a motion, a formal written request, for you to extend the time in which you have to file your what's called a note of issue here in New York. That's the document that notifies the court that all discovery is complete and now there's nothing further to do except put it on the trial calendar and wait for it to be called for trial. It does not guarantee that the court will agree with us, even though my adversaries had consented and have no opposition to what I am asking for. There is no guarantee that the court will agree and go along with this particular request. In that event, I'm going to have a significant procedural legal problem. So what do I do? Because I'm still stuck between a rock and a hard place. I need to advance my client's case, which is critically important. At the same time, I need to protect my client's rights. And how do I do that? By making sure I go ahead and obtain these 2 depositions, which are still outstanding. They're still remaining. So how do I do that? And what alternative strategy do I have in order to accomplish that? Well, I'm glad you asked the question. The solution, the easy solution, is to reach out to my opponents, my adversaries, let them know about this dilemma. And they will know exactly the dilemma I'm referring to. Why? Because they know that they have been obligated to produce these witnesses all along. But yet, for whatever reason, because of some scheduling difficulties, they have not yet produced them. But they had anticipated that they were going to produce these witnesses for the purposes of moving this case forward. But now they had not yet done so, and we were now approaching this deadline. So from their standpoint, the defense's standpoint, they're looking pretty good in some respects. They're saying, oh, wait a second, Oginski has to put this case on the trial calendar, which means discovery would be finished, so we won't have to produce these doctors for deposition. Well, not exactly. Because if I am forced to make a formal written request in an expedited fashion to the court, I am going to lay out to the court exactly how the defense has delayed in producing these witnesses within the time frame the court demanded. And now the onus is not going to be on me to explain why they failed to do that, but rather the defense is going to have to come back and explain to the court why they failed to produce their witnesses in a timely fashion. So I had nothing to do with the delay here. It falls solely on the defense. Okay, having said all that, what's the solution? The simple solution is to get my adversary, who is supposed to produce these 2 doctors for deposition, to agree to produce them for deposition, despite the fact that I am required to put this case on the trial calendar. Even though discovery actually ends technically when I file this document, as long as I get their consent and willingness to still produce those 2 doctors for deposition, despite the fact that the court has now forced me to go ahead and file this document and put the case on the calendar, if I can get them to do that, then I have no problem going ahead and putting your case on the trial calendar. In that instance, I now have written confirmation from them that they will agree and honor their commitment to go ahead and produce these 2 doctors. And assuming they are honorable and are acting in good faith, now I have to trust them to the point where if they fail to do that, and now we get called up for trial and they have still not produced their doctors, now I will ask the court for sanctions and for penalties and fines as a result of their actions in not producing doctors that they had previously agreed they would produce. So why do I share this quick information with you? I share it with you because it's a very challenging, very difficult position to be in, because I need to get these depositions done, but at the same time I need to put the case on the trial calendar in accordance with the court's order and directive. And failing to do that, if the court is not willing to push that date back, now I have to seek an accommodation from the defense, and if they are willing, great, there's no problem. Now I know we can go ahead and get their depositions. At the same time, I now know that I can go ahead and put the case on the calendar and we continue forward. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.